Okay, thank you for the kind introduction, Christian. So, I mean, the topic looks a little bit, tricky in a way. By looking at this topic, you see the relation between free trade and free smoking. I'm not sure if there is a concept called free smoking. I just want to see how free trade is being challenged, at least as far as smoking is concerned in the WTO. This is a new case, as Christian said. It is generating a lot of controversy in the WTO and other forums as well. So I will not have a ready-made criticism of the decision. The decisions have not yet been made. Just to see what possible issues could be raised in this case, particularly in the context of WTO, restricting smoking in a way, or cigarettes in one way or another. Will that be a challenge for free trade? Is it really justifiable under the free trade world or not? And that's just a few insights in that regard. I think I don't have to tell you that tobacco is harmful to health. I think this is I think very basic. Everybody understands, and there is no dispute, by the way. I have never come across a dispute about the harmful effects of tobacco products. We still use them, we still smoke them, but it's, I think, very clear. And actually, a very interesting observation from the World Health Organization states that tobacco is the only legal consumer product that kills when used exactly as intended by the manufacturer. It's the only consumer product. So, as intended as the manufacturer has produced, it kills, obviously. And there is no question about that. Can you think of any other product? I'm talking about consumer products. So I think, the negative health effect of tobacco is just very clear and straightforward. It is also killing many people. If you look again the WHO data, you see that each year about 6 million people die of this. And there is a direct connection. And even non-smokers, passive smokers are also dying. About 600,000 of them die simply because they are, smoking it indirectly from others. So millions of people also start smoking, especially young people. Oh, sorry. Okay, so much about the data. It's very clear. It's killing people. It's addicting people. There is no question about that. Now, one of the measures, different countries have been taking measures to at least limit the negative effects of tobacco use. And one of these measures, which is getting currency nowadays, is what we call plain packaging of tobacco products. The assumption is that the way tobacco products are packed and sold may have a positive effect and a direct relation with the increasing trends of people smoking cigarettes. So one way of combating this is to control the way these products are packed, the size, and so on and so forth. Many countries are now considering. I will come to this point in detail because this is the main area. This means plain packaging will remove the attractiveness of the package, at least. If you look at some of the packages, they're really so attractive. They look like chocolates or candies or something, They are so attractive, especially for young people. So young people could easily be attracted to tobacco, simply because of, the package is one possibility. So addressing this issue may help in combating the use and abuse of tobacco products. That's the assumption. Now to our main case. Australia, so many countries were contemplating about this for long, but Australia has happened to be the first country to legally require plain packaging of tobacco products. They say that 3 million Australians smoke, including age 14 or over. 15,000 Australians die every year because of smoking-related complications. So Australia has been taking several measures to combat this problem. It's considered to be a health care crisis and problem in Australia. So they have been taking several measures, like many other countries, such as restricting, the advertisement of tobacco products, and very clear warning clauses in the package of cigarettes and so on and so forth. But finally, the number of smokers did not decline with these measures, and they came up with another more drastic measure this time. It's called the Tobacco Plain Packaging Act. So this act, which was adopted in 2011 and became operational since December 2012, has really introduced a very significant change in the way tobacco is to be traded in Australia. Several changes were introduced with this law. Well, the government says that this is part of the strategy to significantly reduce people who are dying because of tobacco-related complications, cancers, blindness, and other diseases associated to smoking, and also to significantly reduce also the burden on productivity. When people are sick, then that may have a direct impact on productivity, and also the Australian healthcare system is overburdened by people who are suffering from this. They have to be treated regularly and so on and so forth. So there should be a measure, and that's what this act is designed to address. So if you look at the objectives are very specific and clear of this act. One, to reduce the appeal of tobacco products to consumers. So it means that this act will make it less attractive. So the packaging is really boring, so to speak, for especially young smokers. So they will no longer be attracted by at least the package, the way it's packed. Increase the effectiveness of health warnings on the retail packaging of tobacco products, and reduce the ability of retail packaging of tobacco products to mislead consumers, because the assumption is that the packaging, the way it's packed, misleads consumers, especially young smokers, could easily be misled by the way it is packed. So, what are the prescriptions of this act? Well, the first prescription of this act is that it prohibits displaying of all tobacco products and packages of all tobacco company logos, symbols, and their images that may have the effect of advertising or promoting tobacco products. That means it's no longer possible to include a logo, to include symbols of the company, and so on and so forth. That's why the name itself is plain. It's just plain. It doesn't really show those exciting and interesting, logos and pictures and so on that may possibly mislead people into smoking. And the color also has been prescribed. It should be, it should be shade drab, dark brown. So you cannot have your, the color of your choice. It cannot be red, it cannot be white. It should follow only this prescription. It also imposes restriction on the dimension and makeup of tobacco packaging. The dimension itself is decided by law. You cannot really go beyond what's prescribed I mean, it's clearly defined by the law. Not only that, the shape of the cigarettes, the sticks themselves, has been prescribed by law. You cannot have your own size or shape. You have to follow all the dimensions are defined by this law. Of course, this law does not prohibit use of brand names, but the font, the color, and so on of the name is also prescribed. Very small font, not very visible. Bigger fonts are the warnings. The warning, I'll come to that. So it also requires an updated and larger graphic health warnings. So 75% of the front packet should be for warning. 75% of it. And the back package, 90%, should be for warning. So when you see the package, I mean, it's all about warning. Just 75% of it, warning. There are small, like, things written down, but nobody will recognize it. At the first sight, you will see the warning. And the colors are scary, of course. This is the way the warnings to be stated there. So it's really a significant regulation of the way tobacco is being traded in Australia. So these are the examples. Some scary, pictures should be part of the packaging. So I don't know, the understanding is that it's not as attractive as it was before. Can you buy this one and then put it in your pocket, and when, every time you pull, what's this? My goodness, it's really scary, so that, people may possibly be scared to. So some of the warnings: smoking causes lung cancer. Smoking causes blindness, and others also here. So if you look at this, it's really not exciting, really. Smoking is so the packaging is really to make you, less and less attracted to smoking. So every time you smoke, you see the pack, and then you will not feel happy. I don't know whether that could be achieved or not. It could be arguable. Will there be a direct relation between this science and the behavior of people? Will they stop? Will discouraged to smoking simply because of this and that? That could be, of course, part of the debate in the WTO. But that's what the prescription says. So the assumption of this act: colorful and stylish pack designs make smoking more appealing. So we should make them less appealing, especially for children. By contrast, plain packaging will present smokers and potential smokers with the truth, especially the warnings, the graphic pictures included in the pack. They may convey the true message that smoking is indeed dangerous, and it may kill, it may bring about other disasters, and so on and so forth. So ultimately, the Australian government believes that this is one instrument among other measures to combat smoking and smoke-related complications. That is the idea. Well, that's about the law, the act, very briefly, for our purpose. Now, the tobacco companies, of course, were furious about this. It's just as good as, blocking their products. It's really significant, regulation and intervention on the part of the Australian government. They opened, attack on multiple fronts, in different fronts. The first attempt was to bring a constitutional challenge in Australia itself, and it was debated in Australia, and tobacco companies were not successful in that. The Australian court simply accepted the justifications of the Australian government, and they were not successful. The other is the bilateral investment treaty. Particularly, this involves one company a Hong Kong company, subsidiary in Hong Kong, and therefore there was a bilateral investment treaty between Australia and Hong Kong. Based on that treaty, it's being considered through arbitration. The outcome is not yet known. The third front is, of course, the WTO. That's the main topic for our discussion now. The WTO. In WTO, of course, companies cannot take cases to the WTO, as you know. They lobby governments, small governments, large governments, to take their case to the WTO, and we have now these cases pending at the WTO. 5 cases, one by Ukraine, Honduras, Dominican Republic, Cuba, and Indonesia. So 5 countries have lodged an action in the WTO, and therefore the case is being considered. The panels, in most cases, panels have been established, and therefore we expect that the decisions may come in the next 1 year or so, possibly. And Australia is now asking that, okay, these are more or less the same case, so I can defend them, together. So they, Australia is asking for joining of all the cases together. And you see, the case is so interesting that it attracts a number of countries as third parties, because some of these countries are considering to take the same action as Australia. So they want to see what's going on there before they, for example, if you take New Zealand has already drafted the same law, a very similar law. And they may, they say that they will be presenting it to Parliament anytime soon. So they are interested parties, they just want to know. Some of them are supporting Australia, some of them against Australia, of course, depending on their interests. So what are the grounds for the attack? Well, different grounds. One, they say that this is ineffective anyway. It does not bring about the desired result. There is no evidence suggesting that plain packaging will actually reduce number of smokers. So it's quite difficult to assume if a person wants to smoke, he or she will be discouraged from smoking simply because of the package. So they say that there is no any evidence for that. I mean, it could even be counterproductive. They say that this may encourage counterfeiting, illegal trade, and as a result of this, smoking may become cheaper, and more people may actually start to smoke because the price will be cheaper as a result. That's one. So they say that there is no connection. I mean, there is no proof, at least. The second, and of course, the legal ground for the attack is basically the TRIPS agreement. Even if there were some mentions about the TBT agreement, the principal ground for attack is the TRIPS agreement. As you know, the TRIPS agreement provides some protection for trademarks, copyrights, patents, and so on and so forth. So this is an issue of trademark. They are saying that our trademark is being taken away because they cannot use their trademark in the package. Because trademark is supposed to be a marketing tool. So when there is a trademark from one tobacco company, you may associate some quality with the mark. Now, that's impossible. You cannot put your logo or trademark on the package, so it means you cannot identify. Even if you can, write in a very small font the name in words. So they are saying that the Australian government is violating the provisions of the TRIPS agreement. And therefore, that's why, you have to justify breach of WTO rules to take actions in the WTO. So the other concern, of course, shared by other companies is, so this could be a dangerous precedent. Today is tobacco, what's next? I think there are also some regulated sectors. The food industry, the alcohol and beverage industry, they are also concerned about this. This is a dangerous precedent because there is sugar, there is calorie issues, and so on and so forth. There could be countless possibilities where governments may be encouraged, if this is accepted, governments may also encourage to regulate other sectors. Therefore, there is some kind of cooperation between the tobacco industry and the food and alcohol and beverage industry because of that view. Of course, if you look at the market, Australia is not really a big country, 23 million people. And according to official statistics, 60% of this smoke, of course. So compared to by international standards, it's not really very big in a way. But I think the fear is the precedents to be set by this. So Australia is first. If it's tolerated, every country may continue. And so many countries show interest. If you look the debate at the TRIPS Council in the WTO, you see that so many countries are supporting Australia. A few of them, of course, against Australia, I understand. So that is considered to be a precedent. That's why they are really fighting against this case. Not because of the Australian market as such, but the larger market in the future. By the way, multinational companies are, of course, behind this attack. For example, Dominican Republic, all the costs will be covered by one. I will not mention names, of course. All the costs will be covered by one company. It's obvious. And it's official. And they are also approaching others to take action at the WTO. So we will cover costs, don't worry about that. And they have also export interest, maybe. So behind all these attacks are, of course, these multinational tobacco companies. Now, let me come to the more specific and legalistic, argument in this regard. The most important provision these countries invoke from the TRIPS agreement is Article 20. Well, if you read Article 20, it's really very simple, straightforward. It says, the use of a trademark in the course of trade shall not be unjustifiably encumbered by special requirements, such as use with another trademark, use in a special form, or use in a manner detrimental to its capability to distinguish the goods or services. I think this is a very direct provision, clearly and obviously applicable to this case. Because the Australian government is not allowing use of trademarks. In other words, trademarks are completely prohibited. So they say that this is a violation. We can use it, and it cannot be encumbered unjustifiably. I just highlighted this because this is really the key phrase in this provision. Well, several issues could be raised, based on these arguments. The first, of course, is, does the Australian Act encumber use of trademarks? Does it? Well, I think the answer is straightforward. There is no question about it. Yes. It's a prohibition. If you cannot use your trademark, it means, obviously, yes. If so, is the encumbrance unjustifiable? Because, you remember, it talks about unjustifiable. So, is it justifiable or unjustifiable? Public health as a justifiable encumbrance on trademarks? This is new. By the way, these issues are known in other parts of the WTO, but for TRIPS, they are very new. And it may take us to also to the old debate. It may generate this old debate. Are intellectual property rights, are they really rights or privileges? In the first place, are they rights or privileges? If they are not rights, if they are rights, then it may have its own implications. If they are just privileges, then it may have its own implications on that. And the onus of proof, who is going to prove? On who, is the burden of proving whether the measure is an encumbrance or not? And the standard of proof. How much proof is required? For example, you remember the tobacco companies were saying that, well, there is no connection. Even if you have this law and so on and so forth, there is no connection. People will continue to smoke. It will not deter them from smoking. There is no evidence for that. So what kind of evidence? What are the standard of proof to be? I think these are the issues that will be, debated and considered by the panel as we go along. Now, I think if you talk about public health, TRIPS and public health, they are quite, public health issues are quite recognized in the TRIPS agreement in different ways. Because the Australian government is saying that this is protection of public health. Does the TRIPS agreement recognize anything with regard to health? Yes. I just mention one example, Article 8 of the TRIPS agreement. Members may, in formulating or amending their laws and regulations, adopt measures necessary to protect public health. So the Australian government is basically saying that, well, I am amending this law or issuing another law because it's necessary to protect public health. So it means I am justified, but that's not simple. You have also, I'm not sure some of you are familiar with this, there is a Doha Declaration on TRIPS and Public Health, 2001. This declaration also recognizes the legitimate interest of governments in health. It actually says that governments have the right to protect public health. And it also says that the TRIPS agreement should be interpreted according to its objective purposes as part of the customary rules of interpretation under public international law. So it means the provisions on trademark should be interpreted in accordance with Article 8, which we saw mentions specifically public health as a key issue in intellectual property. Not only that, out of WTO also there are some actions being taken against smoking, and some people that smoking is becoming maybe outdated and outmoded. There is I'm not sure if you are familiar with this Framework Convention on Tobacco Control. WHO has adopted this. About 176 countries are party to this convention. By the way, this convention also clearly says that what parties to this convention should consider adopting measures to restrict or prohibit the use of logos, colors, brand images, or promotional information on packages. And you see that the measure taken by Australia is very similar, actually, to what's prescribed by the WTO Framework Convention on Tobacco Control, where you have 176 parties. So there appears to be emerging state practice on restricting, with regard to restricting how tobacco is being traded. So there seems to be a consensus that tobacco should not be traded like candies, because it's dangerous. A number of countries also support, and they simply are planning to follow Australia. So there appears to be a move towards, restricting this product, which is obviously dangerous. And as you know, trade agreements should not be interpreted just contextually. I mean, following the specific provisions. They have to be more dynamic, and they have to take into consideration several contexts and developments in other areas too, as part of public international law. So I think if we take all this together, one may argue that, well, in theory, there seems to be a strong ground to make a link between, public health measures taken by Australia and possibility of restricting trademark under Article 20 of the TRIPS Agreement. One may argue that there is a justifiable reason to restrict the trademark of these companies. But there are more difficult issues, maybe. The one is, I already mentioned to you, is there any link between the measure and the objective? In other words, will this measure be able to achieve the objective? You remember, for those people in the area of trade law, you know what necessity means. Remember, if you go back to this, it says, I just highlighted, adopt measures necessary to protect public health. It means that, well, at least in theory, there should be a link between the measure and the objectives. Can you achieve this objective by taking this measure? So that could be a challenge. Why? Because, first of all, it's very difficult to see or to bring some kind of evidence suggesting that, well, yes, I have taken measure, and then the result is this. It's just coming now. So Australia may not necessarily be in a position to show that, yes, the measure I have taken resulted in reduction of the number of people smoking. That could be a challenge, but my assumption would be that, and by the way, in this regard, the WTO panels and the appellate body are flexible in this regard. Simply because there is no evidence, it doesn't mean that you cannot take public health measures, depending on circumstances. So since this is the first time, it's the first time being implemented, I would say that the panels may not probably require a high level of evidence showing the link between the measure taken and outcome, because the outcome has to be assessed after certain period of time after it's implemented. So that's a possibility, but that could be one challenge for Australia. And the onus of proof, who is going to prove that? That is also one question. Is it Australia that should prove that the measure it has taken will result in reduction of number of people or some kind of positive result in smoking? Or the companies, the other way around, is the companies should prove that there is no any link between smoking and the requirements of packaging. That's again another important question the panels have to grapple with. And another important question, standard of proof. Because there are pieces of studies, they remain to be inconclusive. Of course, it depends on who funds those studies. I saw a few studies and they say that there is no connection. And when you look at the background, it was sponsored by tobacco companies. So some suggest that there is a direct link, some not. So there is inconclusive evidence about that. But then, I think this should be also flexible in a way. Panels and WTO appellate body has never asked, as far as I know, a conclusive evidence as such. And in most cases, there is no conclusive evidence for everything. As long as there is suggestive evidence showing the possibility that, these kind of restrictions may help in the reduction of people smoking cigarettes or tobacco, that could, in my view, be taken into account. And the last, maybe, before I maybe leave the floor for discussions, questions, etc. How about, are we targeting the wrong thing in a way? If the problem is the product, why do you care about the trademark? If the problem is cigarettes, why not you just ban them? Or at least you take that measure against the product themselves. Because there is no problem as far as the trademark is concerned, there is nothing. It's just a trademark. It's neutral. And it was not challenged as such by anyone. They are illegal or contrary to public moral or whatever, they were not challenged. They are just neutral. So if the problem is really the product, why should you target the trademark? Why not you take whatever measure you like on the product rather than the trademark? These are issues to be addressed maybe in the panels that are established. These are not the only issues. I know there could be some other issues, but I think let me stop here and see if there are any comments or questions or something. Thank you for